Welcome to the Subro Sessions podcast. This podcast provides insights into the world of subrogation. I am Chris Konzelmann from White and Williams, and today's podcast deals with pursuing claims against minors and their parents. There are a couple of general topics that we're going to talk about today. Number one is where we see these types of claims. Number two, the legal standards that apply. Number three, the need for a guardian when you pursue a minor. Number four, parental liability, both statutory and common law. And number five, insurance coverage for losses of this type. We do periodically have to address the situation where a minor, somebody under the age of 18, does something wrong which causes a loss. And going back to the very early days of my career, I actually had to take one of these cases to verdict back in the mid 1990s. And it was a case that I will not forget for a number of reasons. Here's what generally happened. It was a townhouse situation, two houses next to each other. Two families were living side by side. Both were young families. The first family had several kids, including a 7-year-old son. In the early morning hours of a particular day, that 7-year-old was looking for one of his toys, and he thought one of the toys was underneath of the sofa in the house. He went and he found a lighter. He lit the lighter because he needed some light. Unfortunately, he lit the lighter underneath of the sofa and he set the sofa on fire. He realized he had done something wrong, went to his parents. The parents came running out, saw the sofa on fire, and the fire quickly spread. They evacuated the house. The other house next door still had a young family inside. That other young family was not given early notice of the fire. But fortunately, after some period of time, they realized there was something wrong. As they were exiting the house, the mother testified ultimately at court that as she was going down the steps, she saw the paint on the stairway wall actually bubbling. That's how much heat was being generated by the fire in the adjacent property. Luckily, they all escaped. I had the claim for the adjoining property owner along with the uninsured loss claim for the tenant. We brought a claim against the 7-year-old, which was candidly a somewhat difficult thing to do. And we also pursued claims against the parents for leaving a lighter in an area that was accessible to the 7-year-old. I had to take the depositions of the property owners that I was pursuing, including the 7-year-old, who at that point was 8 or 9 years old. And it was an unusual deposition, as one could imagine. And ultimately, we were unable to settle the case, and we had to take the case to verdict. Before the trial, the trial judge did grant summary judgment to the 7-year-old using the laws that were in place at the time of the fire. We proceeded to try the case against the parents for leaving the lighter in a spot that was accessible to the 7-year-old. The jury deliberated for a short period of time, and ultimately the jury found in our favor and found the parent liable for negligent supervision, more specifically, leaving a lighter in an area where it was available to the 7-year-old who gained access to the lighter and accidentally started the fire. The jury did find liability for us. They did not award the amount of damages that we wanted. It was primarily a personal property lost by the uninsured tenant where they took a reduction, but we won liability nonetheless. So these cases do periodically come up. We do have to periodically litigate these cases, and these cases present their own challenges. So, where do we generally see these claims? Number one, in an intentional act situation. Where does that occur? Vandalism, spray painting walls, breaking windows, breaking into homes and having parties inside of homes. Those types of acts that, sometimes people under the age of 18 get involved with. We also see them in the basic, I'll say, non intentional act situation, a basic negligence claim where a juvenile or a minor accidentally starts the fire or accidentally causes damage. And we all talk nowadays about the battery fire situation. And obviously, a lot of minors have electric bikes, electric scooters, electric toys, electric games. And if those products are not charged the right way with the appropriate charger, you could have an overcharging situation which causes a battery failure. If the minor is the one that was doing the charging and did not comply with the instructions for doing the charging, and the failure to comply with those instructions caused a fire, We may have a claim against the minor there as well, along with the parents. So we do see these claims. We are going to see, I think, more and more of them with the battery failure situation because we're generally seeing a lot more of those claims nowadays, regardless. So, what are the general legal standards that we need to look at when we evaluate these claims? And preliminarily, it truly depends on the state that you're in. What are the laws in that state concerning liability of minors? And generally, the states fall into a couple of different categories. The first category is generally kids under the age of 7. And in many jurisdictions, there's a presumption that someone under the age of 7 is incapable of being negligent, right? So again, it goes back to what the state law dictates in that situation. But generally speaking, there is this initial timeline that if you're under a certain age, incapable of negligence, subject to a potential rebuttal of that presumption of non-liability in the appropriate circumstances. And then we generally see kind of the next category. The next category, ordinarily in that 7 to 14 age range. And there, the standard is a little bit different as we begin to realize that during that age, people, juveniles, minors can do something wrong and they can understand the concept that what they're doing is not appropriate or not in conformity with the appropriate standard of care. So, for these category 2 type cases, again, depending on the jurisdiction, there may well be a presumption that the person can be incapable of negligence, with the presumption becoming easier to rebut as the child gets a little bit older. So the claim is evaluated one way if the child is, say, 8 or 9, and a different way if the child is 13 or 14. So if we get back to that e-bike charging example that I referenced earlier, does someone in the 7 or 8 age range truly understand the potential hazards that are associated with improperly charging an e-bike? A pretty good argument can be made that they do not. As that child gets closer to 13 or 14, the argument becomes a little bit easier to make. So we're evaluating these on a case by case basis. We then get to the third general category, children 14 and older. Generally speaking, they're presumptively capable of being found negligent, but that presumption can also be rebutted with appropriate evidence. When you're evaluating these cases, the first thing you need to do is look at what the act was that caused the harm. You then need to determine the age of the individual, and you need to evaluate in that particular jurisdiction where you're located, what is the presumption? Is there a presumption of non liability? Is there a presumption of liability? It's going to depend, right? But that's kind of step one of the analysis. And if the juvenile can be found potentially liable, we do the traditional negligence analysis: duty, breach, causation, and damages. So again, we're looking at these on a case by case situation. What was the act that caused the harm? Number two, what does that law say in that particular jurisdiction on liability of that minor? So that kind of gets us past the initial part of the analysis. If you decide to pursue a juvenile, one of the other things that you need to keep in mind is that at some point in time, somebody is going to need to be appointed as a guardian for that minor during the course of the litigation. It's going to be a jurisdiction specific analysis. There's going to be a question as to whether or not the defendant has the obligation to name the guardian, whether it's done by motion, whether it's done unilaterally by the court. You're going to have to determine what the particular procedural rules are in that jurisdiction. Ordinarily, a parent can be the legal guardian. The analysis gets a little bit more complicated, though, if you're pursuing a claim against both the juvenile and the parent on a negligent supervision theory. An argument can then be made that there's a potential conflict because the parent is the defendant or a defendant. And can a defendant be a guardian over another defendant? Again, the inquiry is state specific depending on the jurisdiction that you're in. Continuing with the analysis, the next question becomes, well, who's going to pay for the guardian? Is that something that if there's liability insurance, the liability insurance is going to pay for? Again, it's going to depend on the terms of the policy and the law in that particular jurisdiction. The next item is parental liability. We talked about liability of minors or juveniles. What liability does a parent have when a juvenile does something wrong that causes harm? The inquiry again is case specific. The analysis falls into two general categories. The first category is statutory liability. In that particular jurisdiction, is there a statute which holds a parent liable for the actions of a minor? Many jurisdictions have those types of statutes. Some are limited to damage caused to school property, and most contain an monetary cap, which is generally a very nominal sum of $1,000, $2,500, or maybe as high as $10,000. That's a situation where, in certain circumstances, the parent can be found statutorily liable for certain types of actions committed by a minor. You're going to have to evaluate the state law in your jurisdiction to determine whether or not such a statute is in place. The next issue is common law. Outside of the statutory scheme, can you bring a claim against a parent for negligent supervision? And the answer generally is yes. You're not seeking to hold the parents vicariously liable for the juvenile's actions. It's not automatic liability just because they are the parents. It's a situation where the parent owes a duty to exercise due and reasonable care. The first question is, what is the duty? Next, breach. Next, causation. And next, damages. So the analysis generally goes like this. Did the parent know, or should the parent have known, that the minor had certain propensities to cause harm? If the child was known to set fires, even if they were very small fires, an argument can be made that the parents had an obligation to take steps to curb that behavior. Along the same lines with this analysis, first question is, did the parents know or should they have known? Next, was it foreseeable that if appropriate supervision was not provided, there would be injury? Next step is, how would reasonably prudent parents have acted knowing the information that they had as to the child's propensities? If we were dealing with a situation with a straight A student, no problems at all, generally speaking, it's going to be very hard to hold the parent liable on a negligent supervision claim. If the child, though, has a history of causing harm through whatever conduct that may be, and the parents knew or should have known about that conduct, it becomes a little bit easier to make the negligent supervision claim. And generally speaking, those claims are not subject to any statutory or monetary caps. Let's go back to the example that I gave before with the e-bikes, which we are seeing more and more of nowadays. We know that e-bikes, scooters, battery powered electronics do cause fires. An argument can be made that if a parent provides one of those types of devices to somebody that's relatively young, an 8 or a 9-year-old or a 10-year-old, there may well be an obligation or a duty to properly supervise the minor during the use or charging of those items. As the age of the individual increases, arguably the potential liability of the parent decreases, because as the minor gets a little bit older, they can understand or should understand the potential risks of what they are doing, which arguably may take some liability away from the parents in terms of having to supervise them. So again, it's a case by case analysis. Does the juvenile have known dangerous propensities, which requires a heightened duty of supervision? Are we dealing with a straight A student with no problems? Or are we dealing with a student that may not be doing as good in school and has a history of problems? In the former situation, it's much more difficult to hold the parent liable on a negligent supervision claim. In the latter situation, it becomes a little bit easier. We also have to look at the age. One can certainly argue that a 10, 11, or 12-year-old requires more supervision than a 17-year-old. right? So that's another part of the analysis that needs to be considered. So there's a good number of questions that need to be addressed when you are evaluating subrogation potential for a claim involving a minor. The next item we need to talk about is insurance coverage. And we all know that generally speaking, there is no insurance coverage for an intentional act. There may or may not be insurance coverage if there's a statute in place that holds the parent liable. It's going to depend on what the policy says. In the more generic negligent supervision area, generally speaking, there's going to be insurance coverage for that, even if the action of the juvenile is considered intentional. But again, it's a situation where you're going to have to review the liability policy, look at the insuring agreement, look at the exclusions. But it is certainly possible that if you're pursuing a claim against a juvenile who intentionally committed a wrong and a negligent supervision claim against the parent, there will probably not be coverage for the juvenile, but there should be coverage for the parent on the negligent supervision claim. So, those are the issues that we generally see when we investigate these types of claims and when we litigate these types of claims. So, preliminarily, what was the negligent conduct that caused the harm? Number two, what was the age of the juvenile? And what does the law in that particular jurisdiction say about when a juvenile can be held responsible and cannot be held responsible for the wrong? What statutory liability, if any, is there for the parent? And what tort liability under common law principles is there for the parent under a negligent supervision theory? All of these issues needs to be looked at, they need to be evaluated, and a decision ultimately needs to be made on whether in that particular jurisdiction you can pursue the juvenile and also whether you can pursue the parent. That was a very brief overview of investigating and litigating claims against minors and their parents. As I indicated, the inquiry is very fact specific. It's also very specific to the laws of the particular jurisdiction where the loss took place. The information that I provided should give you a good understanding of what you need to consider. But again, you need to consult counsel to determine what the law is in the particular jurisdiction where you're investigating and litigating that matter. Thanks for listening to this episode of Subro Sessions. Be sure to listen to the next episode of Subro Sessions, which will be released on the third Tuesday of next month, April 16th in this case. You can find past episodes of the podcast and relevant case updates on the Subrogation Strategist blog, all available at whiteandwilliams.com.
We would like to remind everyone that the contents of this podcast should not be construed as legal advice or to give a legal opinion on any specific facts or circumstances. Prior results do not guarantee a similar outcome. The contents of this podcast are intended for general informational purposes only, and you are urged to consult a lawyer concerning your own situation with any specific legal question you may have.